kind of go high level snapshot overview, because I think that this point here is a very good point. You've got to choose the person that you actually want to go with. Then in between this point and this point, there's actually quite a lot in terms of finding and identifying and negotiating on the contract. Then we receive the contract, right? So we speak to the real estate agent. Hey, I really like this deal. Send me the contract. I'm interested. Send me any disclosure documents. That would be amazing. Then you take that contract to your legal advisor, and then you say, yes, this is something that I think is really worthwhile. In the meantime, you're already looking at the property. You would have already gone to the property to check it out, or you're going to it at the weekend. You would have already spoken to your mortgage broker and built up that financial approval. If you're buying it at an auction, you would have already done a property inspection, and you also would have already read through all the contract and any disclosure documents. Then what happens is you then put forward an offer to the agent, which is going to have your clauses and your contracts in there. What are the special conditions that you want?
In contracts, there are terms that you must do, and then there are essential terms. And if you don't do something that's essential, that then creates a breach. And in some states, the seller has to give a notice to remedy that breach in a particular time frame. It's not done, they can terminate the contract. So, but in other states, if that notice isn't required, and if you haven't paid on time, they can terminate the contract straight away. And you might have paid, let's say the deposit's $10,000, you might have paid $5,000 by the due date, and then you don't, you're planning to pay the balance a few days later, but you haven't asked your lawyer to extend that deposit payment date. You'd be in breach of that contract. The seller could actually terminate, keep that $5,000 deposit you've already paid. Yeah. So really important, if you're going to pay a deposit late, to make sure you first get the deposit payment date extended and agreed to by the seller.
Wow. Okay. That's a very good point. Very, very good point. I bet that happens a lot. And then people just kind of breeze over it. But there can be people that just say, no, I'm keeping it, canceling the contract, and I'm going to go elsewhere.
Yeah, there's been plenty of cases about it.
So, okay. So what exactly are property searches? Like, you hear this thing, property searches. Like, what is it?
Well, going back to those buyer beware regimes, where the seller doesn't attach any of the searches about the property, these are the searches that the buyer needs to do to make sure there's no issues with the property. So obviously those compulsory ones we spoke about, the title, the plan, the land tax, the rates, the water, but also those other things, like the council approvals, like the main roads, heritage building, things like that. And that, there's usually there's a list of these in each state, and there can be as many as 20, sometimes 30 potential searches you can do for a property type. And it's up to a buyer to really consider, how many of those they do. And they often say, well, you tell me. And so what we do anyway with our search lists is for each search, we have a little explanation. So you should consider doing this if the property is of this type, right? And so they can then work out, okay, well, the property's not this type, so I'm not going to bother with that kind of search. But these searches can add up to be, hundreds and hundreds of dollars. But of course, hundreds of dollars isn't a lot to protect and manage your risk when you're buying hundreds of thousands of dollars worth of property.
So let's say we've gone unconditional on our contract. What is like behind the curtain? What is the behind the curtain stuff that we're looking at that conveyancers do? So they do the property searches, they set up and do stamp duty. So making sure that exact number is up and set up correctly.
Yeah, and the stamp duty, and there's forms to complete for that, and there may be concessions or and discounts in certain states for certain kinds of buyers. Generally, for property investors, there aren't, unless you're buying off the plan in some areas. But you still need to complete forms in that regard. And then the next one was obviously signing mortgage documents is critical to do that as quickly as possible, because that's going to be the number one cause of delayed settlement. And your bank's going to send that to you directly. Broker's going to organise that for you. Where we might get involved is where there needs to be independent legal advice on a guarantee. For example, if you're buying a company of trust, the bank will want personal guarantees. They'll want to send you to a lawyer to get independent legal advice about that guarantee, in person guaranteeing that loan. And on this, traditionally, well, most states still, technically, the Law Society's position is that you need to see someone face-to-face in their office to get independent guarantee advice. But in New South Wales, they do accept it being done remotely. So what we do is, doesn't matter where you are in the country, we get one of our New South Wales lawyers to organise a video conference, for example. We give written advice before the meeting. We watch you sign the guarantee documents, video record it, scan an email copy back, we countersign, put the necessary wording and forward it on. So it can be done remotely, which is good in that process. But yeah, otherwise you have to go and see someone face to face.
What are some of the most popular clauses and things that you see in contracts? So maybe I'll go through some of the more common ones, which is I want a pest and building clause in here, and I want a 14-day finance clause. What are some of some of the high value?
Depends on the state, because that's not like you don't get a 14-day calling off. I mean,
Sorry, did I say cooling off? 14-day finance clause. So a 14-day finance.
The finance clause is often disguised as a cooling off period in New South Wales. So rather than asking for a 14-day finance, just say 14 days cooling off, because you can negotiate. There's a statutory period minimum, unless it's waived, but you can negotiate a longer cooling off period. So they're the big ones. We touched on due diligence before. You might even want to narrow the scope of due diligence. So we spoke about unapproved structures. So you might want to say contract subject to the buyer being satisfied that all the structures have been approved on the property. That might be another 14 days to do that. It's also, I see a lot of, it's becoming a lot more popular where there's subject to sale clauses. So, if it's a downsize or an upsizer, well, I'm going to buy a property first, lock that in, but I need to make it subject to me selling my property. They can get complicated, but are often needed. If you have the ability to negotiate, that's great. And it becomes a bit of a chain, like in the UK. So in the UK, a lot of sales, other than first home buyers, they're all chains. So they have all these contracts sort of linked together and subject to each other happening. And something doesn't happen on time, and you could be waiting months and months and months for your settlement over there. So you're starting to see a bit more of that happening in, particularly in slow markets. That's pretty common.
David's put here electrical and gas clause. What is he?
That's sort of kind of unique to Western Australia. So it's one of those. They have some industry standard annexures that they attach to a contract. Structural defects, pest, timber, electrical and gas, just to make sure they're in working order, essentially. That's recommended for WA for existing properties. That allows
you to skedaddle, or the vendor has to fix that issue, right? You can't just end the contract. The vendor can say, oh, I totally appreciate and I identify that there's a gas issue. I will have that fixed, and that clause you won't be able to escape for whatever reason. It'll be fixed and you can't escape.
It really comes down to the terms of the special condition annexures there. And I know in our practice, we thought some of the industry standard ones weren't great for buyers, and so we submitted our own drafted versions on behalf of clients, and we just rejected outright by conveyancers in Western Australia. And so what we ended up doing was changing the font to look at just like the industry standard font, and they were accepted. So, which seems bizarre, but people just wouldn't read it. They just assume, that looks normal. We're comfortable. We're used to that. Well, that's fine. We'll accept it.
Have you seen that happen in a contract where an agent does that? They put like a crazy condition, but then they move it somewhere and they put it in a similar font that looks like the stock standard. Have you seen that happen before? I mean, you guys are doing it clearly, but
agents aren't legally allowed to draft clauses. Okay, so drafting special conditions in a contract is considered giving legal advice. What agents can do is copy paste special conditions that have been drafted by a lawyer or conveyancer and put them in a contract. But they can't just come up with their own, because that would be only lawyers can do that, and it'll be it's illegal essentially. So if they were to do something like that, if they were to rearrange, especially a lawyer draft or something standard, there could be implications on that. But I think the bigger thing for property investors to know is that when buying off the plan, of course, there's very often they don't use the standard contracts, and that very bespoke contracts, particularly for apartments and townhouses. There's no legal requirement to use a standard form of contract. Of course, you can use any contract; it can be one pager, as long as you have all the statutory disclosures and things like that. So if you're buying off the plan, you really need to get a lawyer to look over that, because they can put in any kinds of terms, and sometimes developers will make their bespoke contracts look standard, have the look and feel of a standard one, to make buyers feel comfortable about it. Even buying off the plan, one today that I saw, it was a standard RIQ contract, but then they have all the terms and conditions in 2 columns. That's sort of the standard RIQ version, and then they had their own special conditions also in 2 columns. Same font, looks exactly the same. So to the untrained eye, that just looks like a normal contract. But of course, those special conditions completely change the standard position in the contract.
Your thoughts on this? Is probably a question on some people thinking about thoughts on digital contract on the blockchain. Have you investigated much? I mean, if you can't share too much of sort of proprietary information, let us know. But has there been many thoughts on that?
Yeah, I mean, it's good in theory, and I think people are working on it, but I think it's a long way off. Okay. What we're looking to do though is developing a national contract. Every state has their own standard version of contract, but how great would it be if you had a national contract and it's not easy because there's essentially 8 different countries in Australia when it comes to property law. So it's a difficult job, but something we're looking at. It really only takes a player in the market with enough market share to start requiring these contracts to be used for it to take off. So that's
how likely do you think that will happen?
I think it's likely. The question is when. And then because there's a lot of industry players to accept it. You've got the real estate institutes, the banks, and things like that.
Yeah, actually, there's a question for you. Which of the states are the most fair, not for the vendor, not for the buyer, but just the one that makes sense for everybody?
Most balanced.
Yeah, what is the one that national contract would be, do you think? Because I think South Australia has a 2-day cooling off period where you can just walk. Like that's not okay. You can't just do that for whatever reason. I don't think that's fair for the vendor. WA, you can just you sign the contract, it's done. Like I don't know what state is making sense the most for this national contract, you reckon?
It's a controversial question.
It is, yeah, and I think it's difficult to say which one has the best balance because they're competing interests, aren't they? The vendor wants to be locked in as quickly as possible, unconditional, and settle without many rights to get out, and the buyer wants the opposite. So from a buyer's perspective, Queensland's got a great contract for buyers because it's very common to have those finance and building pest conditions, and it's better now because of that 5 business day extension, right? But then the contracts and the practice in New South Wales is heaps better for sellers because it's practice to make sure that the contract is exchanged unconditionally.
Yeah.
But that can obviously give rise to gazumping, of course. So gazumping is where you're not locked in. Yeah, you're not locked in. So you're negotiating, buyer and seller negotiating something, negotiating a deal. The buyer's doing all their, pre-purchase inspection reports. They've agreed a price through the agent with the seller, and they're almost ready to exchange, but haven't done. But then the seller gets a better offer from someone else, and because that first buyer hasn't exchanged on the contract, no one's legally bound at that stage. Another buyer comes in, exchanges beforehand, they get the deal, that first buyer has been gazumped. So it can happen, and it would happen more so in those states where it takes longer to exchange because it's unconditional exchange. But of course, balancing that is, agents would get a bad reputation if they allow gazumping to happen on their watch. It's probably more likely to happen directly when a buyer and seller are dealing direct with each other.
I did hear a story recently, and I don't know if this is it's like secondhand, so it's not anything. I don't know anything really about it, but she was saying that she had a contract fully unconditional. It went past cooling off. It went past the pest and building clause. It went past the finance clause, and we're just in that weird period between settlement and unconditional exchange. And in that time, the vendors had a divorce, and the wife put an encumbrance on the property as ownership, and then she pulled out of the contract. Yeah. And then the banks saw that and said, "Hey, there's an encumbrance on the title that's above our lending. We're not going to lend to you anymore." What the heck happens in that situation?
Well, it sounds like it could be something like so where there's a family divorce or separation. Often a property is not even owned by both couples, right? So for asset protection, for example, our family home, it's my wife's name for asset protection purposes, and I've got the properties in my name. But so even though that's the case, I'm still equitable owner. I may not be on title, but I'm equitable owner, and I'm on the mortgage. But in that case where there was separation, the other party who wasn't on title would register a caveat over the property. A caveat is an instrument that on title that prevents dealings happening. So the owner can't then sell the property to someone else without that caveator knowing about it. So if that happened, the wife may have said to the husband, "Well, I want half the sale proceeds of this." And
unless you agree to it, then I'm not taking the caveat off.
Didn't take it off, and settlement failed because you can't transfer that title with a caveat. So that's possibly happened there. And then what does the buyer do? Well, you essentially you have to sue the sellers for breach of contract. But having the right to sue,
give you what do you get for?
Well, you go to court and ask for specific performance or for damages. Yeah. So the court can order, the sale to happen, or for the sellers to pay damages. But the court process is lengthy, uncertain, expensive, very costly. Most people try and avoid it.